It is with great honor that I introduce Professor Dr. Chidananda Reddy S. Patil, an eminent academician, distinguished legal scholar, and a leading contributor to legal education and reform, currently serving as the director of the Karnataka Institute for Law and Parliamentary Reform, Bengaluru. After graduating from the University of Mysore, he pursued his LLB from University College of Law, Dharwad, and went on to secure his LLM from the University of Mysore with first class earning 2 gold medals. He later obtained his doctorate in law from Karnataka University, Dharwad, cementing a strong foundation in legal scholarship. With over 3 decades of experience, he has been associated with premier institutions such as JSS Law College, HE Law College, cail Law College, and University College of Law. His academic leadership has been equally significant, having served as a dean, a syndicate member, academic council member, and the director of cail Law School. What truly distinguishes him is his substantial contribution to legal research and scholarship. He has authored a book, edited 4 scholarly volumes, and published over 85 research articles in reputed journals. His expertise has also extended into law reform and governance. He contributed to the Committee on Reforms of the Criminal Justice System under Justice V.S. Mallimath and played an important role in drafting the Karnataka State Human Rights Code Rules 2006. Beyond all this, he has demonstrated a strong commitment to social justice. For over 25 years, he has been actively involved in legal aid and literacy initiatives, working towards making law accessible to the broader public. Professor Dr. C.S. Patil stands as a symbol of academic excellence, intellectual rigor, and public service. It is indeed a privilege to honor and celebrate such a remarkable personality. With great pleasure, I now invite Professor Dr. C.S. Patil to address the gathering.
Good afternoon. It is so nice to be here in the Christ Academy Institute of Law again and again. Professor Dr. K.G. Sanesar, former Vice Chancellor, National University of Advanced Legal Studies. We have a very strong bond. He was in Kerala University, Trivandrum. I went there. He was in Wales. I went there. He was in Central University. I went there. Wherever we celebrate association because we related to each other in the absence of these gadgets. Okay. Now you are happy with your own gadgets. That's why that freedom of association clause, one more clause was added. Freedom to form cooperatives also has come into the Constitution now. You have to exercise this freedom of association sometimes. Sir, it is so nice to speak in your presence in this great institution. Father Davis Pranadhan, he let the cat out that I evaluated his PhD thesis. He had done a marvelous work, but all of you have this complaint that you are marked low, no? When the results are announced. You are not happy about the assessment generally. So I was a bad assessor. But the quality of thesis was very good. Really we celebrated, and incidentally I attended the convocation of National Law School when he took his doctoral degree from the National Law School, and that initiation has developed into a strong bond of relation, and it continues. Dr. Sinijan Ma'am, Vice Principal, Dr. Nandu Sam Jose, the coordinator for this conference. Dr. Sharada is accompanying me. She is a member of the Academic Council Karnataka State Law University. Maybe a lead from here will go to KSLU as to what is the academic activity that is happening in the Christ University Institute, Christ Institute of Law. This theme is very fascinating and challenging. Since yesterday maybe you are exposed to different panel discussions and all that. See, we have no alternative but to bother about these topics. There is a great responsibility upon all of us. First, because we are citizens of this country. We are not subjects. We are not subjects, we are citizens. When Britishers were ruling us, we were subjects. After independence, with our own constitution, we are citizens. And when the chapter on citizenship was adopted in the Constituent Assembly, you should be very, very consciously appreciating this fact that we have gone for civic nationalism. We have not gone for ethnic nationalism. Sri Lanka shall be a Buddhist state. They have written it in the Constitution. We have not written like that. Right? When you see this chapter on citizenship in the Constitution, you will make out that the Constituent Assembly members debated elaborately and they opted that India should go for a civic nationalism. Okay? Not ethnic nationalism. The type of debates and discussions that are going on right now, you as students of law, first, be very, very cautious, concerned about the developments that are taking place. Because we are citizens, that's part of the chapter of Constitution which has gone for civic nationalism, and because we are students of law, we have a onerous responsibility of reading, rereading, understanding and propagating the values that pulsate in the Constitution of India. This is not an ordinary document. Constitution of India is not an ordinary document. I really hope and pray when Rajpath is renamed Kartavyapath, and when this IPS understand that he is at service, when this fellow IAS understand that he is at service, then the country of our dreams will be there. They are not here to rule us. Okay? Rajbhavan has become Lokbhavan. So nice. Rajpath becomes Kartavyapath. So nice. We have to move in this direction. A person who is a servant should understand that he is a servant, otherwise he should be made to understand that he is a servant. And the sovereign should feel that he is the sovereign. There is a principle, subsidiarity principle, that is highlighted in the second Administrative Reforms Commission report. People are sovereign in this country. If I talk to a common man and tell him that you are the sovereign in this country, he will say, Professor, why are you joking? None of us feel that we are sovereigns in this country, because whatever we dictate will not happen. Father Davis was right on the point. Look at self-government. See, these are the people elected, they take decision and they name the streets, they impose the tax, they collect revenue and they implement the policy decisions that they have taken. Right then and there it is happening, they feel that they are the sovereigns here. Because things are happening as they decide. That should happen at the local level, that should happen also at the national level. This is not an ordinary constitution. We play with words, transformative constitution. When you read that book, Granville Austin, Indian Constitution, the cornerstone of a nation, then in the wake of that, fundamental rights and directive principles contemplate social revolution in this country. Revolution never means that it should be a bloody revolution. There can always be bloodless, silent revolution. There should be social revolution. And this person, Granville Astin, survived to see the celebration of Golden Jubilee of the Constitution of India. And having seen working of the Constitution for 50 years, he writes another book, Working of a Democratic Constitution. Both the books are there in the library. I told one of the last students who is interning with us, gentlemen, there is a book like this. Then that fellow said, sir, I have seen that. And I said, you are a boy, you should see girls, read books. Books are not to be seen. Books are to be read. Books are to be studied. Books are to be understood. They are there in your library. Choice is yours, whether you want to see the book or whether you want to read the book. And in the second book, Working of a Democratic Constitution, he writes, what is Constitution? Constitution is what is available to people. What is available? See, all this is written in the Constitution. But what is available to me is my Constitution. All else that is there in the Constitution, it is there. It is like a holy book kept on a pedestal. I cannot reach the holy book. And this holy book, we should not keep on a pedestal. This is a book to be read, this is a book to be understood, this is a book to be operationalized. And this is a book to be challenged also, wherever necessary, change also if it is necessary, debate, discuss on that. And don't distance that from the real life. Don't treat like any other book which cannot be reached, which cannot be touched. When we speak of this theme, governance and rule of law, we have to very seriously consider certain of the issues which Professor Sunny has already dwelt upon. We have celebrated 75 years of our Constitution. When you Google, you will make out that average life of the Constitution on earth is 19 years. Constitutions will not survive beyond 19 years. And ours is 75 years. It has survived 75 years. See, Pauline Harriman, in one of the books, writes he writes like this: constitutional institutions are strong enough to withhold the onslaught of unscrupulous incumbents. You have these constitutional officers, sometimes people come, but the Constitution survives. Where is the proof? The proof is that it is 75, we have celebrated 75 years of the Constitution, is the proof. So this is a Constitution to be read, understood, interpreted. Please read this book, Constitution of India, Miracle, Surrender, Hope. Wonderful. The very fact that we have a Constitution is a miracle. The author asked this, Rajiv Dhawan, asked this question: if we are asked to frame a Constitution for India now, we will not frame the Constitution which is equal to the Constitution of India. And it is a miracle that those people, constitutional forefathers, have framed the Constitution for us. And what we have done, through this Constitution, we have surrendered ourselves to politicians and judges. There was a mentioning about the judiciary, final interpreter of the Constitution. Okay? So we have surrendered ourselves to the politicians. There is an electoral process. Dr. Sanghi is an expert in the field of election laws, and when he is introduced, you have made out that he was part of the team that was sent as an observer to Bangladesh, Nepal and other things, the electoral area. See, constituents should be translated into legislature through a process. And the process that we have adopted is this election and that first past the post system, somebody gets elected there. After so much of discussion, debate, we introduced nota in that, none of the above, but nota. Okay? Recently, in the parliamentary election, in Indore probably, there was uncontested candidate. There was only one candidate in free because the other person's nomination was rejected. For the first time it happened in India that a member of the parliament was elected uncontested. Sir, you have to enlighten us. When there is only one candidate in the fray, whether there should be an election between Nota and this candidate or not. Whether people should be allowed to vote or not. As a citizen of this country, I have this right to vote. Most basic in the democracy. And if there is only one candidate, I am disenfranchised. I have lost my right to vote. Whether by any means and methods, any democracy, a section of the people can be disenfranchised. These are the questions with which we have to bother as citizens of India. It has held out so many things to us. Okay. All those great principles of social justice that are there in the directive principles. So that is one fascinating. Whoever the government, he cannot do whatever he wants because these principles are there. Otherwise, the constitution will be interpreted to be a bourgeois constitution. Because of these elements of social justice, the strappings are there on the government and on the judiciary also. We had elections recently in 5 states. The Indian elector is a person who is beyond the contemplation or guess of any pundit. Any pundit who says, I will analyze elections, I will predict election results, etc. Pundit, there is a pun, P-U-N, there is a pun in pundit, and this fellow pundit will become a pun if he goes near our elector. The Tamil Nadu result was beyond contemplation of anybody. How people of Tamil Nadu have voted is wonderful. No, none of us contemplated that. This is the result that will speak. So these people got up in the morning and went and stood in the long queues. Who are these people? Poor people, unattended, uncared for. But these are the people who got up and went. The record percentage of polling this time in all the states. Who are these people? These are the people whom the democracy let down. And these people who are let down by the democracy go and stand in queue for the democracy. That is the beauty of this country. And the way they vote, they teach lessons. They teach lessons. See, Dr. B.R. Ambedkar in the Constituent Assembly cautioned, whatever the Constitution, whatever the structuralization of power in the Constitution, if a single party is voted with thumping majority, there will be a possibility that it will lead to dictatorship. It will lead to dictatorship. When you analyze the election results, the parties with the thumping majority have come to power, and next election that thumping majority is reduced, so that they will understand who the elector is, who is the sovereign in this country. There was a wonderful principle that was given out by Honorable Professor. 3 centers: executive, legislature and judiciary. And there was a mention about lawmaking process, participative, whatever. That report as to how laws are passed in this country. At the end of every session of the parliament and any state legislature, we read in the newspaper that in the last 15 minutes, 12 bills were passed. In last 20 minutes, 15 bills were passed, something like that. So, 1 minute a bill is passed. What discussion? No discussion at all. And probably no private member bill is ever considered, debated and passed in this country. Wonderful private member bills. If you log into PRS, you will understand how beautiful. You see, the right to be forgotten is a bill introduced by Supriya Sule in the parliament, but it will never be taken up for discussion. Right? So this is what that is happening. Bills are passed without discussion. What type of participative democracy it is when bills are passed without discussions. And we have seen what happened to formulas. Bills were passed, notified, and the government could not bring them into force. And Supreme Court also has to interfere in the process. How laws are made? Somewhere there is a criticism that Parliament is a sort of notice board, wherein people will be called and instructed, look, this is what we are doing. Understand? Now we can go. No. Parliament should be a place of debate, discussion, consideration. Amendments should be moved. Otherwise, what rule of law state we will remain? That is the problem. And in Karnataka we are proud. In terms of transaction of legislative business, in last year, as assessed by PRS, Karnataka is the number 1 state in terms of transaction of legislative business, with around 42 laws enacted. Second is Tamil Nadu, Delhi is last in terms of transaction of legislative. The business of the legislature, you are talking the first LLB that there is a legislature to legislate. They do everything without bothering about their primary function, legislation. Why this has happened like this? It has happened like this because lot of this function is taken over by executive. Executive has overstepped its power, and there is a caution. There is a caution that there may be a situation wherein executive will reduce the legislature and judiciary to rubber stamp. Okay? Judiciary in a democracy should have deference, respect for the mandate of the people. But Constitution is supreme. As long as the legislature is staying within the constitutional framework, court has to have deference for what the legislature has done. Beyond that, court should be there in order to strike down whatever that is there. In a rule of law state, there is what is known as Delhi Declaration on Rule of Law, 1959. In a rule of law state, there is a duty on the legislature, every legislature, to create an environment wherein every individual can be his best self. That is the environment that is to be created. That is the duty on the legislature when you speak of rule of law. And we have forgotten what the demands of rule of law are, and we only hope and pray that someday that will happen. Legislature will become very conscious. In Karnataka, we have a law whereby the legislature itself that the legislature should meet at least for 60 days in a year. 60 days in a year, but unfortunately we are not in a position to match that record of 60 days also. We are performing less than that. That is the state of affairs. And beyond that, participation. As students of law, whenever you come across the fact that a draft bill is open for discussion and debate, make it a point to send a mail. Because you are the law student from the prestigious institution, let there be an email that goes to the parliament that whatever opinion, one nation, one election, whether it should be there or it should not be there. Send your opinion. Maybe right, maybe wrong, and generally it will be right because you are fresh minds. And our government in Karnataka has started decentralization of legislative process, and as Father Davis told you, this was one of our research teams, which has drafted 11 legislations for the government of Karnataka, which I presented through Law Minister to the Chief Minister of Karnataka. Quite a few of them are selected, and now the State Law Commission and CAIL together we are finalizing certain of the bills that will go to the House next. And I am so happy that so many students also participated in this project from the Christ Academy. That is a very big exposure for whoever boy, girl who participated in that. We did not have such a facility when we were students. Day before yesterday, when we considered the speed breakers, law for the purpose of regulating speed breakers after the meeting. So during the process itself, Honorable Justice Ashok Inchigiri was appreciating the draft, especially the technical and precise language that was used, those expressions. And Dr. Irfan Rasool was with us in the meeting. Other professor missed that. He was appreciating, and at the end of the meeting, again he called Irfan and made a special mention of the contribution. And after coming here, I learned that Dr. Singh is also a co-author of that. So this is what that happens. If we sit back, we will not be known in Vidhana Sabha. But because you came forward and participated in this exercise, now people in Vidhana Sabha know that. They know that there are people here in this institution who can make quality contribution. We may not like we them. We them has classified India as not democracy. India is not put in the list of democratic countries. Right now they have classified India as an electoral autocracy. As an Indian, I do not like this, that we are in an autocratic state. But they have their own parameters. I may reject their parameters, but I have to consider how qualitatively the democracy can improve. That's why Raju Dhawan writes in his book, Hope, Miracle, Surrender, Hope. The hope is that one day all those promises that are there in the Constitution will be translated into reality, and the citizen of India will get whatever that is contemplated in the Constitution. This is the hope. Please, as students, after you become a professor like me, you will stop reading. As a lawyer, you will be reading only when you are paid. It is the time when you have to read. I really get fascinated by the names of the books. I have told in my earlier visits also. Lawrence Train, reading the Constitution. Reading the Constitution. The first chapter, how not to read the Constitution. A subheading there, reading the Constitution should be writing the Constitution. Making of the Indian Constitution, B.N. Rao, making of the Indian Constitution. Constituent Assembly was the constitutional advisor, here it's making of the Indian Constitution. Subsequently, Justice H.R. Khanna writes, Constitution in the making. So that fellow making of the Constitution over. Now this fellow, Constitution in the making. Right? Then the Dhananjay Chandrachud comes and he writes, why the Constitution matters. Why the Constitution matters. And this fellow Falin Ariman, you must know your Constitution. I have a specialization in constitutional law and I have 2 gold medals. I joined as a professor, retired also after that this book comes, you must know your Constitution. Oh Baba, I will know my Constitution. I started reading it again. Really a very fascinating book. I enjoyed. And after that Shashi Tharoor writes, our living Constitution. Oh, come on, our living Constitution. Read it. And the latest, Indira Jaisi, Constitution is my home. And tomorrow I will get this book, Constitution is my home, and I want to check how my home is. It is not that simple. Governance and rule of law, as embedded in all these great works, as students of law, we have to understand, celebrate, and cherish. Thank you very much for the effort.
Sir, the depth of your insights and experiences has made the session truly meaningful.